Welcome to the fifth episode of TCLM One on One. Through the One on One series, we aim to interact with the best legal professionals from India and around the world. Today, we have a guest who needs no introduction amongst the legal fraternity. He is a senior advocate of practicing in the Supreme Court, Madras, and other high courts. He is also the author of authoritative commentaries on constitutional law, central excise, and income tax law, and the very famous book Nani Palkhiwala, The Courtroom Genius, chronicling the journey of Nani Palkhiwala as a lawyer and his case. We have none other than senior advocate Arvind Datar today with us. Sir, thank you for the opportunity. We are truly honored to have you.
Thank you. Thank you for inviting me.
Sir, to set the tone for the interview, you have written authoritative commentaries on constitutional law and allied subjects, as well as tax law. How did you develop this love for legal writing, and what role has it played in your career?
I have been writing since my school days. I was for some time editor of my school's small newsletter, and then when I started practice, I had very little work. I used to take lectures at the Institute of Chartered Accountants and Cost Accountants, but that was not sufficient to keep the income going, because in those days in 1980 we were paid 20 rupees for 4 hours for a lecture. Of course, there was a lot of money in those days, but that was not enough. And then I thought that by writing articles, I read somewhere in the British Council saying that you must write and get known. People should know who's Arvind Datar, who's Shashwat. How do they know unless they see your name in print? So I decided to write articles. So I set myself the target of writing one article a week, because I didn't have much of work. And in 2 years, I wrote 77 articles, basically on tax in all the other journals. And we had many tax journals. So I wrote on all the journals. I wrote for Economic Times, wrote for Business Standard, and so on. That's how I started writing articles. And then that gave me a lot of mileage, a lot of visibility. I started getting invited to seminars and so on. And then I decided to write a book, because I was going to practice in central excise, and I decided to write a book, which I knew it was a Herculean task. It took almost 2.5 to 3 years to write it. So I started writing, partly out of necessity and partly enjoyed it. And then I realized that writing is the best way in which you can really understand a particular subject. Suppose you're doing something on legitimate expectation. If you're writing an article on that, then you will necessarily read all the important case laws. You'll see the development of the law, the historical background, how the law has developed from, say, 1949 to 2019. So legal writing, I think, enables you to get some amount of mastery over a particular topic. It can be legitimate expectation, it can be promiscuous topic. Whatever you're doing, legal writing is really helpful in understanding the subject completely and totally.
Sir, you joined the bar way back in 1980, if I'm getting the year correct. So,
yes.
How has legal education transformed from the time you studied law to the present day system? What are the key differences that you can see today?
Yeah, well, the first difference is we didn't have any 5-year course. We had only a postgraduate course. So people who joined the law college had either done a BSc degree, like I did my BSc honors, physics and mathematics. My colleagues had done BA literature or BA economics. Quite a few commerce students had come. So it was a postgraduate degree, 3-year postgraduate degree. A 2-year degree was called BGL, Bachelor of General Laws. And then you had to do 1 more year, which entitled you to an LLB degree. I still feel that was a better system than the present 5-year system. I think that at the 12th standard, you are not fully aware of your likes and dislikes. And I think only after a basic graduation, I think you're really ready to take up a course like law. That's my personal view. So one important difference is the 5-year course vis-a-vis the 3-year course. In Bombay, you also had a very good system of part-time colleges, and people would go early morning to law college and then they would work the whole day. That was also an interesting system. It was the best combination. I think you studied law in the morning and then worked in the law firm. So you got theory and practice simultaneously. So that was the thing. The other important point is that we never had so many moot competitions and essay competitions. Nowadays, because of the huge expansion of law schools, law universities, national law schools, and so on, there is far more amount of moot competitions. So I think the younger generation is more equipped. I think they are far better trained than we were. And by the time you enter the bar, I think if you're serious if you're seriously interested in legal studies, you would have taken part in MOOCs, either as a speaker or as a researcher. So I think the biggest plus point in today's system is the extensive amount of MOOCs that takes place. Secondly, I think you've got the unbelievable advantage of the internet, where you got almost all the important sites are at your just a click away, literally speaking. So you've got a huge amount of knowledge which you can access. For us, we had to go to the library. If it was a book not available in the law college library, then you go to the judge's library, get a special permission. All that you can just sit in your home and get the information to do. So I think that there are pluses and minuses, but I think on the whole, today's system is better because you can be much better trained to be a good lawyer. I think if you just keep the new modern technology and go back to the old system of a postgraduate degree, it would be the best for law study. That's my view.
That's an interesting take, sir. Taking cue from that, sir, law students and young practitioners often face this difficulty of deducing the essentials of a statutory provision. And that's mainly because today law schools don't actually train law students how to effectively engage with the statute book. So, sir, how should one go about reading a statutory provision?
Actually, I'm quite surprised that you are not, present law schools don't do that, because when I was studying in Madras, the third year we had a complete 1-year course on one full paper, 100 marks paper on interpretation. And I remember buying my first copy of Maxwell's interpretation of statutes. I think that what we should do is that the law schools must have a course on interpretation, and otherwise I would recommend every law student to buy a copy of G.P. Singh's interpretation of statutes. Without meaning disrespect to any foreign book, I think that is perhaps the best book on interpretation anywhere in the world. That's my opinion. It's an outstanding book, and late Justice G.P. Singh put in a lot of work to write this wonderful book. So all of you, including yourself and your colleagues, please buy a copy of interpretation and read it as often as you can.
There is a peculiar problem with Indian judgments. Almost all the landmark rulings are mammoth in size, and the size makes it very difficult to retain the important principle. So, how should one go about reading a judgment? What is the effective way of doing that?
Yes, that is a bit of a problem, because in landmark ruling, whether it's the privacy case or the Aadhaar judgment or the 377 case, you have multiple judges, many judges of the bench writing their own opinion. As an author, I do find it difficult to sometimes get the ratio. Now suppose there are 7 judges and 5 write separate opinions. I would take it that if A, B, C points have been held by all, then that's the LCM. That is definitely the ratio of the entire bench. What happens if one judge makes an additional point in the majority that is not commented upon by the other judges, or then what happens? Is that the ratio? According to me, that's again a grey area. But this is not an Indian problem. For example, if you take the UK judgments also, you take the Bank Mellat judgment, or you take the Belmarsh judgment, there are multiple judgments by various law lords, and different views are taken. And I think it's necessary. What I normally do is I try to prepare a table and put judge A, B, C, D in columns, and on the rows I put what are the issues, and then just get a rough idea of on each issue what judge has said, what paragraph numbers. So you get some kind of an Excel sheet of the judgment, which helps you analyze what is the ratio. That's the only way out. Yeah, because you can't stop the judge from writing multiple judgments. I don't blame them. Suppose they feel that after hearing a case for 7-8 days, they want to make their own contribution to jurisprudence. I think it's most welcome. I don't see size is a problem, but it has got its own plus points.
Exactly. Most certainly, sir. You have been a staunch critic of the tribunalization process, especially when it comes to sectoral tribunals. Having appeared in landmark cases such as the National Tax Tribunal case, Company Law Board case. What are the fundamental problems with sectoral tribunals in India? And do you think that India should try to replicate a model from England wherein there is a supervisory body over the tribunals?
Well, I've been battle against wholesale tribunalization. I use the word wholesale tribunalization, indiscriminate tribunalization. for the last, I think now 30 years. I want to make it very clear that tribunals are necessary. You can't do without tribunals, especially in tax matters. Like you got the sales tax tribunal, the income tribunal, the GST tribunal. They are very, very important because you have a wonderful combination of a judicial member and an accountant member, and both put in their inputs and you get the law. Secondly, the High Court is then concerned only with the question of law. High Court doesn't have to worry about the factual part of it. That is taken care of at the lower level, at the tribunal level. So there are certain areas where tribunals are necessary. But it is my view, after so many years of research and experience in studying almost the entire global scene on tribunals, that we should not have tribunals where the two litigants are private parties. For example, you take the debt recovery tribunal. What's the purpose in having 3 debt recovery tribunals in Tamil Nadu? You can have 3 district courts can become the courts for banking cases. You don't need a separate tribunal with a separate bureaucracy, registry, some retired judge there. The same district judges can exercise the functions of debt recovery because it's basically a civil dispute. So, but at the same time, say it's a FEMA tribunal or income tax tribunal, it is necessary, I don't say. Now, so one is to clearly demarcate what should go to tribunals, what should stay in the judiciary. That is point number 1. Second point is you create a tribunal and then don't supply infrastructure. Again and again, there's a problem. Many tribunals, they have a tribunal, for example, the Company Law Board, Shastri Bhavan, for almost more than 10, 12 years, it was just in one room on the 5th floor where you had many, many cases. And very often, all the lawyers alone could not be accommodated in the room, you alone the clients. So, of course, things are better now. But second problem is the lack of infrastructural support. Secondly, this system of having 3-year tenure is very, very harmful, and it is quite shocking and sad that the government completely ignores Supreme Court directives of making minimum term of 5 years. The Legat Committee in England, Lord Legat Committee, said it should be at least 7 years into 14 years should be a term of tribunals because then they get expert. Other thing which I'm championing and trying to promote is the possibility of an Indian tribunal service. Because, say, young lawyers who would want to go to the district judiciary, want to become judges in the higher judiciary or the higher district judiciary, etc., they can go to tribunal. Suppose you are a person who has learned taxation. At the age of 45, why can't you become a judicial member of a tribunal and be a member for 20 years? If you're lucky, you'll become a High Court judge also. So have a tribunal for 3 years. Let younger members of the bar, who normally will become district judges or civil judges, they can join these tribunals. Take consumer court. Why can't it be manned more and more by lawyers? So tribunals have got a place, but I think the way we have gone about it is completely wrong. We are now taking it as a post-retirement place where mainly civil servants and some judges after retirement are there for 3 years. Very often the particular presiding officer or member, he has no expertise in that branch. Like you have a person who will be in the environment tribunal who has never done environmental law. You'll have a person in the authority of advanced ruling who has no knowledge of tax. So this is a problem. You have a specialized tribunal with generalist members. So this is a huge mismatch.
So, you have rightly pointed out a fundamental problem is with the uniformity between different tribunals. So, going to another important issue, by the virtue of the Supreme Court's ruling in the AGR dues case, the telecom companies are finding themselves in a serious fix. Now, you represented one of the companies in the matter. How will this judgment impact the telecom sectors?
Well, impact is a mild word. It has devastated the telecom sector. Devastated. Because I have no quarrel with this Supreme Court holding that AGR is payable on the gross revenue. Though I seriously feel that if I'm selling my, say for example, this cell phone for 20,000 rupees and I give a Diwali discount of 4,000, I don't pay sales tax on 20,000. I pay sales tax on 16,000. If I'm clearing it on a discounted price, I pay excise duty on discounted amount. So universally, any levy is always on the net amount and never on the gross amount. When they talk the word of gross revenue, they mean the revenue from all sources, not that the revenue with the discounts. That's one part. Secondly, where it very badly hit the telecom sector was the interest and penalties. The interest was something like 1% a week compounded. It was absolutely unbelievable interest which will embarrass even a pawnbroker. So interest killed the I think out of 92,000 crores, almost, if I'm not mistaken, I wrote an article on this. I think almost 65,000 crores is represented by interest and penalty. So if they had levied that tax, that would have been no problem. This dispute was pending for 13 years. Why punish them with penalty and interest? So it has really seriously impacted the telecom sector.
Will it also affect the investments, sir, in the sector in the coming years?
The point is, if I got an expansion project, I'm never going to enter into the telecom sector. I will never. Very unlikely that we'll get a foreign investment in the telecom sector, because I don't know when the law will change, what view the government will take. Because even for the telecom industry to take the view that gross revenue includes everything under the sun, including rent, dividend, etc., is completely bizarre and absurd. That was not the intention when we had revenue sharing. What are the revenue sharing models? If you earn money from telecom business, I'll take 10% of it. But that doesn't mean that you will take something on which I don't earn at all. So I don't think any foreign company will now, like how Vodafone came in or Idea came in, nobody will enter the Indian telecom industry with an FDI for telecom.
Lastly, sir, what are the changes you see in the bar today, and what would your advice be to young litigators joining the profession?
Well, the changes are many. I think change is inevitable. When I joined the bar in 1980, it was completely different from what the bar was in 1960 or in 1950. The whole law changed. It shifted from zamindari legislation, land legislation, to slowly getting into writ legislation. So it's going to constantly change. What will be most certain is change. We have to accept change. Only thing is, we should be ready and be responsive to meet these challenges which every change brings. So I think among the plus points today is huge advancements in technology. We can have video conferencing. There are many ways in which we can perhaps do much more. We can increase our productivity manifold with the help of technology. That is one part. So technology is a great assistant, a great friend, which can help us dispense justice better. On the worrying side is the failure to fill up vacancies quickly. Today we have almost 40% of the high courts are still vacant. We have massive vacancies in tribunals. So on the judicial side, tribunal side, vacancies is a serious problem. On your last question on the advice to young litigators is that, as I've said in another interview also, I think the main thing is specialization. One thing is patience. And the other thing is, don't rush to specialization. You first try to get basic knowledge of civil law, criminal law, and then you go for specialization. That's been my advice to all my interns and all my friends whose children are doing law. And I tell them that just wait, because you're looking at a 50-year career at the bar. There are no retirement age, right? So you join the bar at 25, and today, because of medicine and people will live much more than we live. So you join the bar at 25, you're looking at least a 50 or a 60-year career at the bar. So don't be in a hurry. Just make sure that you learn the basics, civil law, criminal law clearly, and then go for specialization. I would also advise the youngsters to completely focus on their career. And I think the less you spend on social media, on other extracurricular activities, the faster your chances of success. One thing is very clear, that life as a lawyer is a very demanding task. It requires undivided 100% attention. If you're going to get diverted with other things, then your success will be that much delayed, and sometimes won't be possible at all. So it has to be law, and nothing but law in your life.
Thank you so much for, again, sir, gracing us with the opportunity. Your journey has been an inspiration to litigators around the country, and for me personally as well. I've seen almost all of your interviews, the recent interview with Madras Tax Bar Association as well. Your views are always fantastic, and your journey serves as an example that with hard work and perseverance, one can achieve whatever he or she wants in the field of law. Like, you do not necessarily have to be from a legal background or have to have someone in the family. You can achieve something with hard work. So thank you so much for gracing us with that.
Thank you, and I wish you and all your colleagues in the forum all the very best. And my best wishes to all your young friends, and I look forward to all of you becoming very eminent and successful lawyers in the next 15-20 years. God bless you all.
Thank you so much.